at the January meeting of the Technical Committee on MA 63 that such a bill would not be presented to Parliament until October 2019. Even then, despite suggestions by MPs from GPS that the bill be referred to a Parliamentary Select Committee for study, it was still put to the vote and ultimately defeated. I am rather astonished that in the aftermath of this historical defeat of the Constitutional Amendment Bill, the de facto Minister for Law had announced that a special Parliamentary Select Committee will be formed to study amendments to the Federal Constitution. This is the exact same proposal proposed by our GPS MPs and which was rejected by the federal government. With hindsight, the minister would have avoided embarrassment to himself and the federal government if he had accepted the constructive proposal from the GPS MPs that the bill be referred to the Parliamentary Select Committee. Dato' Amar Speaker, as appears from the recent media statement from the Minister for Law, there would be a Parliamentary Select Committee on amendment to the Federal Constitution. Thus, I am moving this motion so that this House has the opportunity to express in clear and explicit terms what amendment to the Federal Constitution must be included in any future constitutional amendment bill to be presented to Parliament, and that the Parliamentary Select Committee that is to be formed will be able to understand and endorse this proposed amendment from this august House. Dato' Amar Speaker, to begin with, it is high time that the Federal Constitution pronounce categorically that Malaysia is a federation formed pursuant to the Malaysia Agreement 1963. It is totally wrong to have the federation defined in Article 160(2) of the Constitution as the federation established under the Federation of Malaya Agreement 1957. No Sarawakian would like to be in a federation formed under the Federation of Malaya Agreement 1957 and be considered as a part of the Malayan Federation. This has never been the aspirations of our forefathers who signed Malaysia Agreement 63 to pave the way for the birth of Malaysia. This amendment is as important, if not more important, than the federal government's attempt to restore Article 1(2) to its original form, but still, we are in the Federation of Malaya. The Minister of Law had said it was to be included in the amendment bill presented to him on first reading that the Federation was formed pursuant to MA 63. We must negotiate as it was not included in the wording in Annex A to Article 2 of the MA 63. This explanation is totally untenable. All that Sarawak GPS MPs seek to do is to reflect reality. And why do we need to negotiate to include a historical fact that Malaysia is a federation formed under MA 63? Making reference to this historical fact in the Constitution would give constitutional recognition to MA 63, which contains constitutional safeguards for Sarawak Agreement to join in the formation of Malaysia, including our autonomy over our immigration.